I will take 4 minutes exactly since, but I appear for Shaparji Palanji, Lord, which is a contractor. We had filed an intervention, Lord, and mentioned yesterday. Lord, I've mailed my note to the court master, and very briefly, I've formulated my points over the lunchtime. I just get copies. Lord, we are carrying the hard copies also, Lord. Lord, very quickly, my points.
The submission?
Lord, my submission is obviously to say that 4 points, Lord, I'm making. Section 7, which talks about arbitration agreement, does not include an agreement on who will appoint. It's only limited to intent to arbitrate. And I'll read section 7. Means an agreement by the parties to submit to arbitration. So once that test is satisfied, the second conditions which parties often put, that unless I appoint, only then I will go to arbitration. Or it can be only from my panel. Then only, that was a question that had come from Lordship in the beginning. What if it is a conditional arbitration clause? But the requirement of section 7 is limited to intent to arbitrate. Right to appoint or unilateral right to appoint or limited to panel of appointment has to be divorced from it. They cannot go together. Once the test of intent to arbitrate is satisfied, then law kicks in.
Yes.
That's my first point, Lord. I put it in my note, submission number 1. And Lord, intent to arbitrate has been recognized in the Cox and King's judgment, which on the group of companies doctrine. So that's my first point. Intent to arbitrate is the first step. As per 7, arbitration agreement has been defined to means an agreement so and so. It is not predicated as to who will have the right to appoint. Thus, existence of an arbitration agreement gets satisfied as soon as the requirement of 7 is met. Now, my second point is there are 3 aspects of constitution of an arbitral tribunal: intent to arbitrate, commencement, and procedure. These are the 3 aspects before a tribunal is in place. Now, 11.2 uses the word parties are free to agree on a procedure. But actually, the main mischief is here. How much stretching do we give to the word procedure? Does it mean procedure in case parties fail to agree? Or would Lordship consider procedure to mean even determining who will appoint among the 2 parties? Procedure will only mean, my Lord, methodology. The real problem is procedure, my Lord. If Lordship gives interpretation to the word procedure in 11.2, the entire problem gets solved. That's the Gordian knot. Because that is where the agreement is referred to, which gets used. That, oh, I have a right to agree on the procedure for appointment of an arbitrator. That means I can decide who will be appointed as an arbitrator. But my submission here would be, keeping in mind the mischief rule, Hayden's rule, purposive interpretation, the word procedure will have to be limited to mean in case parties fail to agree, then what is the procedure? Lord, that is what is the fallback also in 11.5, Lord. Then 11.8, which Mr. Banerjee had referred, my Lord, has the words independence. And it also uses the word other considerations. Lord Lordship had put a question, what is their other? Those other considerations would kick in because it's a very wide term. Lord, on section 18, my Lord, I have referred to the judgment of PAM development, which had made section 18 applicable to even post-arbitration. And my Lord, on panel, my Lord, I have just 2 points to make. What cannot be done directly should not be done indirectly. If Lordship is permitting one party to appoint an arbitrator, then panel will be justified. But if one party can't appoint a sole arbitrator or the presiding arbitrator, then even panel cannot be justified. Lord, if 3 people cannot be appointed by 1 person.
So tomorrow we'll start with the arguments of the Solicitor General.
Lord, one request, Lord, my colleague says the intervention may be formally allowed, Lord.
Yes, we allow it.
I'm grateful.